Testing the sound for Zoom. Okay. Okay, we're gonna get started. So as I said, there's CLE sign-in circulating for the Zoom participants who are getting CLE credit. There's 2 slides throughout the course of the presentation that have the CLE codes. For those in person, you don't have to worry about the codes. Okay. Hello, good morning. So my name is Lily Millwit. I'm the Housing Not Handcuffs attorney at the Law Center. I'm going to do a quick intro, but our panelists are Diana and Joe, and I'll introduce them and turn it over to them really quickly. I just want to sort of situate us in why we're talking about exclusionary zoning, particularly within the context of criminalization of homelessness. Our movement is quickly learning that the criminalization of homelessness comes in many forms. In addition to the common forms of criminalization that we see and that we talked about a lot yesterday, such as legislative bans on sleeping outside, sitting and lying down, panhandling, living in vehicles, zoning law has also become a really insidious but incredibly harmful way in which homelessness is being punished around the country. Municipal zoning laws are being used to attempt to legislate shelters, non-traditional housing, and encampment sites out of our communities. Institute for Justice is one organization fighting back against these types of laws. In one of its more recent cases that I know Diana and Joe will talk about with more expertise than I will, they represented the Catherine H. Barber Memorial Shelter, the only shelter facility available in all of Wilkes County, North Carolina. While the Law Center does recognize that congregate shelter facilities are not adequate housing solutions and do not solve homelessness, we also recognize the importance of preserving and expanding shelter facilities in communities where no housing or non-congregate shelter exists. In these circumstances, shelter facilities, and especially those like the Barber Memorial Shelter that attempt to break down barriers to entry and promote accessibility, autonomy, and dignity, may be important harm reduction tools. When the Barber Memorial Shelter sought to move to a larger, more centrally located space in Wilkes County, it was denied a use permit based on the zoning board's decision that the space would not be, quote, harmonious with the neighborhood. The shelter challenged the permit denial in federal court, represented by Institute for Justice, and won. The Western District of North Carolina, of all districts, held that to attempt to distinguish the shelter from other similarly situated use permit applicants based on the clientele it serves reflects nothing more than improperly using a land use regulation to regulate people. Courts correctly show deference to state zoning regulations, but such deference cannot be an excuse for the court to abdicate its duty to protect the constitutional rights of all people. While homeless individuals face many challenges, attaining equal protection of the law under the Constitution ought not be one of them. North Wilkesboro intentionally treated the shelter differently from other similarly situated uses, and there is no rational basis for the difference in treatment. This is impermissible under the 14th Amendment. This case is just one example of the ways in which zoning laws have been weaponized to exclude people and services from communities, to create and sustain racial and economic segregation, and to exacerbate existing disparities. These types of laws dictate how spatial power is allocated. They tell us who gets access to opportunity and who gets proximity to wealth. More importantly, they tell us who doesn't get access to opportunity, who doesn't get to exist in public space or be a part of their community. If this sounds familiar, it's because laws that criminalize homelessness, sleeping bans, prohibition on loitering, panhandling, and resting in public spaces are directly related to the types of zoning laws that would rather zone unhoused people out of existence than allow its residents access to a warm bed at night. Because of this important connection to the urgent work of decriminalizing homelessness, and because zoning has become a popular means by which the growing NIMBY movement preserves socioeconomic caste, we are very excited to hear from Diana and Joe from Institute for Justice. Oh, I meant to have this when I was talking about other laws criminalizing homelessness. So really quickly, Diana has been at Institute for Justice since 2013 and litigates to protect private property and other individual rights with a particular interest in challenging irrational zoning decisions and abusive fines and fees practices. Joe has been at Institute for Justice since 2021 and has also worked on property and zoning cases, including a case filed last year in state court challenging Calhoun, Georgia's ban on construction of any new homes less than 1,150 square feet, attempting to legislate out of the community those whose preliminary and primary pathway out of or safety net from homelessness may be to rent, buy, or build smaller homes. So I will turn it over to them and also move my laptop so that the Zoom participants can see them. Here you go.
Thank you. Okay, well, good morning. Thank you all for joining us. I'm delighted to see how full the room is. That makes me very happy. So I just want to start by telling you a little bit about who we are at the Institute for Justice. We're a nonprofit public interest law firm, and we work to end widespread abuses of government power and secure the constitutional rights of all Americans to pursue their dreams. One of our major areas of focus is property rights. And so in this, we litigate eminent domain on behalf of property owners who the government tries to take their property, civil forfeiture on behalf of people whose assets the government tries to seize and forfeit, and of course, zoning, which is why we're here today. And so I want to talk a little bit, I want to start by talking about the zoning code, the different zoning codes and how they treat homeless shelters. And so they all kind of approach it from a slightly different perspective. Some of them prohibit all non-specified uses. So if there is a zoning code that allows, 200 different types of uses, if it is not one of those uses listed, it's just flat prohibited. And so these kind of flat bans often include the more traditional uses, so residential or a restaurant or even the trash dump, but they are perhaps insufficiently creative, or perhaps that's by design, and they deliberately exclude uses that they don't list, which often includes homeless shelters. Some zoning codes limit disfavored uses to just a few zoning districts. And so they'll put them in kind of particular parts of town that are either difficult to get to or just disfavored generally, so that other people can't see them. And some zoning codes subject disfavored uses to very restrictive permit requirements. And so I'm going to spend a little bit of time talking about each of the different types of permits that kind of exist in zoning codes. And so the first is a permit issued by right. This is a pretty traditional zoning permit. It is issued by municipal staff. It's pretty easy to get. And so it is granted so long as the use is in the appropriate zoning district. There is absolutely no discretion for each of them. And they are, pretty easy to get. We also have a permit with additional standards and conditional use permits or special use permits. I use those phrases interchangeably because a lot of different zoning districts and different towns do as well. So talk a little bit about each of these. So the permit issued by right, this is what I mentioned just a moment ago. So what you have on the screen here is a portion of the table of uses in the zoning code for North Wilkesboro, North Carolina. And I'm picking on them just because this was the defendant in our case about the Catherine H. Barber Memorial Shelter. And so I am intimately familiar with this zoning code. So I'm going to use it because it's easy for me to talk about. So for a permit issued by right, if you'll see this highlighted zone here, this is for a restaurant without drive-through service. This is just an example. There are 5 different zoning districts that a restaurant without drive-through service can go in. And so what do we have here? We've got 3 business districts. So that's the neighborhood business district, central business district, and general business district. I guess 4. And then we also have the highway business district. And then there's the light industrial district. So if your proposed use is in one of those districts, you submit your application, your fee, you show that it's in this particular location. That's it. You get the permit. There's no discretion. That's it and done. And it's great. It's easy to do. The next type of permit is a permit with additional standards or a permit with supplemental standards. And so this is similar to a permit issued by right in as much as it has to meet specific requirements that are identified in the code. Once you prove that you meet those, the permit is then issued by municipal staff. There's no discretion. It's fairly easy to get, again, as long as you meet these particular requirements. So up on the screen, I have an example of a group care facility, which this particular municipality defines as essentially a residential drug and alcohol rehabilitation facility. And so As you can see, it is allowed in 4 different zoning districts. The one on the left is the rural residential district, and then office and institutional, general business, and highway business. And then you see on the far right, it's a supplemental standards, and then there's a zoning code, or a different part of the code. So you then go to the code and you see the different standards. And so here the standards are that they have to have a written operating procedure or manuals. They have to have established goals and objectives for people receiving therapy or treatment. There has to be a structured management with a board of directors. There has to be on-premises management with supervisory personnel. There has to be admission standards allowing those with a commitment and desire to adjust to society and are not dangerous to others. There has to be at least 250 square feet of heated building area per resident, and it has to be at least half a mile away from another group care facility. So you can quibble about what, these requirements and whether they should be authorized, but you can see that, again, this isn't a discretionary list. It's either, do they have this? Check yes, check no. So once an applicant submits their application, their fee, they show that they're in the right zoning district and that they meet these standards by, providing evidence. So for example, providing your written operating procedures or manuals. That's it. Then the zoning staff has to give you the permit and then you get to open up. Oh, there's a CLE credit. So if you're a remote attendee, the code word is zone. Okay, special use permits. So this is the most restrictive, and this is the one that was at issue in our case that I'm going to talk about a little more detail later today. But a conditional use permit or a special use permit, it's issued only after a hearing and approval from the municipality. And so that's either from the city council or an appointed zoning board, something like that. And so this example I have up here is for a homeless shelter. And so homeless shelters can only go in the highway business district, and it's subject to a special use permit, and again with supplemental standards. So you go through the supplemental standards here. It has to be at least 2,500 feet from another homeless shelter, has to be at least 250 feet from a residential property, public park, or school, has to have a public sidewalk, has to have supervision and security via staff that are trained in emergency procedures. You have to have at least 50 square feet per occupant, and it has to be in harmony with the area in which it is located and general conformity with the comprehensive plan. So, does anyone know what the word harmony means? I don't either. I've been trying to figure out what the word harmony means in these zoning codes for years. And so every time I take a deposition in one of these cases, I ask them what harmony means. And I get some bumbling answer about, oh, well, it fits. Well, I don't know what that means either. How does a particular use fit in an area? But I can rag on harmony all day. But anyway, so what an applicant has to do with a special use permit is they have to submit their application with their fee and all of that, showing that they're in the right location, showing that they meet these supplemental standards, that they then meet additional standards for conditional use permits, which I'll show you in just a second. And then there's a quasi-judicial hearing that is open to the public and includes public comment. So the decision is then made by the elected or the appointed municipal officials, and they decide based on these factors, as well as these required general findings that they have to meet in order to grant a special use permit. And so North Wilkesboro, North Carolina uses a board of adjustment. The members are appointed by the mayor. They're not politicians per se. It's not a political board. There's no oversight of it. Different municipalities kind of have these in different versions. And so sometimes it'll go directly to the city council, which is a political entity. But in any event, the Board of Adjustment holds a quasi-judicial hearing and has to find each of these 6 factors in order to grant the special use permit. So it won't materially endanger the public health or safety, that the use complies with all regulations and standards, that it won't substantially injure the value of adjoining property, or it's a public necessity. The location and character is in harmony with the area, So that's a second harmony requirement that we have to meet. Public water and sewer service are available and adequate, and that it won't conflict with the most recent comprehensive plan. So each municipality has a comprehensive plan that they set out saying, you know, this is how we envision our city looking in 20 or 40 or 60 years or whatever. And it, you know, it won't conflict with that. So some of the challenges with special use permits. The application is quite extensive. You have to prove a lot of things. You have to demonstrate a lot of things. They're very expensive to compile. You have to submit a site plan, which usually requires an engineer. That's expensive. And they typically require hiring a lawyer. And so it's one thing when you have a hotel that's, you know, a $50 million project or whatever, applying for one of these. It's just part of the business. It's something else when you have kind of a smaller community-based organization that has to go through this. And of course, subjective requirements. I've already ragged on harmony a little bit, but again, I don't know what harmony means. I really don't. It's in the eye of the beholder, and people can use that to kind of cover all differences of opinions and why they don't think it should go there. Because they have these subjective requirements, they're very difficult for unpopular uses. They also provide neighbors an outsized influence on whether a use can go in a particular area. Almost all of them require that neighbors be notified of the application. And then when the hearing is, and then they give them an opportunity to speak. And so when they're given that opportunity to speak, it is, if it is a disfavored use, they let that be known typically. And zoning boards are just regular people who are often persuaded by neighbors' concerns because they're not politicians, or perhaps even when they are politicians, they're concerned about making a decision that is unpopular or difficult for the neighbors or whatever. So some better practices, treat homeless shelters as similar uses. Don't require a conditional use permit, don't require a special use permit. Just go and look at the rest of your zoning code. How do you treat other overnight uses that provide shelter to those in need? So nursing homes, hospitals, group care facilities, all of those different types of uses that let people sleep there overnight, they're all using the land in the same way. And so treat them in a similar fashion. Of course, don't require conditional use permits or special use permits. Those permits with additional standards, that seems like a much better way to do it, because then they're just objective requirements that you can either check or not check. What happens once the permit is denied? You typically have to appeal through state court procedures. This has a short appeal window, usually 30 days. They're often subject to these exhaustion requirements, which mean that you either have to go from the Board of Adjustment to the City Council, to the state courts, or just directly from the board to the state courts. You're often barred from going to federal court. There are benefits and drawbacks to litigating these cases in federal court as opposed to state court. But if you want a fresh set of eyes, sometimes the federal court is the better place to be, but you're limited because of these exhaustion requirements. Except for when you're not. Always be sure to check the applicable administrative appeal statutes. So up here on the screen, we have an example from North Carolina of the statute that they passed in 2020 that is just a phenomenal statute. I love the statute because it allows you to take a zoning appeal to either Superior Court, which is in state court, or federal court. And you can do this as an original action, and then you can join it with an administrative appeal. And so that's what we did in North Carolina. And so it ends up, you can bring it subject to 1983 and then attach this administrative appeal as a supplemental claim. And then you have your whole case in front of one judge and you can make all the claims together. Again, you know, we thought long and hard about whether to do it in state court or federal court. We decided we wanted to do federal court in this particular circumstance. I'm happy we did. We got a big old victory. But this statute was the reason we were able to. And so we were combing through all the statutes. Sometimes these statutes don't exist and you have to, you're stuck in state court. But that's okay. So anyway, so that's kind of the general zoning code treatment of homeless shelters. I know I covered a lot in there. Should we take questions at the end or throughout? What would you prefer, Lily?
Whatever you guys prefer is.
Okay. Well, if you guys have any questions, I'm happy to, yes.
Why did you decide to bring it in federal court?
So we were concerned about getting hometowned, if you will. And so because homeless shelters can be a disfavored use sometimes, we were concerned about the impact of a local judge seeing it and not wanting to deal with it. We also had a US Supreme Court case called Cleburne, which I'll talk about a little bit later, which is often ignored, but still good law. And, you know, you can talk about US Supreme Court cases in state court all you want, but they have a little bit more impact, I think, in federal court. And so we also there weren't any additional options under the North Carolina Constitution, for example. It didn't provide greater protection than the US Constitution. And so we weighed a lot of different factors and ended up in federal court. Yes.
How involved are developers, Chamber of Commerce types in doing this?
Very. So I guess it depends on the application. In North Carolina, there was the statute, and then there was a good case in 2020, actually, on behalf of a big hotel that had been applying for a conditional use permit and was denied for spurious reasons. And they ended up litigating it to the North Carolina Supreme Court. They got this great decision we were able to rely on. But again, that's a $50 million project. You know, they were able to afford attorneys to represent them at the hearing and then throughout the litigation, and that's expensive. You know, we're a nonprofit. We represent our clients for free. You know, I think most people can't afford that kind of representation, but developers sometimes can, and sometimes they get their carve outs, or sometimes they'll go and kind of butter up the politicians or the municipal decision makers. So that it's usually, by the time it gets to the hearing, it's kind of a foregone conclusion. Yes.
How much variety is there from like locality in terms of who are the decision makers and what the criteria of the different zones are?
You know, it really depends on each municipality. I've seen some with city council decision makers. I've seen some with boards. I think the boards are perhaps the more frequent decision makers. I don't know why that is. I've never really been able to figure out kind of rhyme or reason to why they do that. Does that answer your question?
Yeah,
Okay.
yeah.
It's a non-answer, I suppose. I apologize. But
Like,
Yeah, I have a question also. I think, so you mentioned an exception for one of the zoning rules as being if it's a public necessity.
yes.
Are there objective criteria for that? Because I would think the only shelter in the county would be a public necessity.
One would think there are not criteria for that, at least in North Wilkesboro. They didn't consider it at all. And so that was an issue we made to the judge, and he ended up kind of talking about it generally, but then striking down their decision on state law grounds for other reasons. But so no, there's not, in this particular code, there's not a definition of what that would be. I would think that a homeless shelter, if you have any use that is just not designed to increase neighboring property values, there's lots of uses that are valuable, but aren't going to increase property values. That would make it a public necessity, whether it's a homeless shelter or whether you're talking about a power plant. I mean, I don't think that would increase the house cost of anyone, but there's still value that it brings. So. Yes.
I know we talked about this North Carolina here, but are you seeing jurisdictions that are implementing those better practices? Like just in general, like maybe like without the special circumstances?
Yeah, so some are. You know, I think there's a lot of room for encouraging municipalities to make better choices. There's just so many municipalities that it's tough doing that. And so, you know, there are certainly some that do it. The North Wilkesboro, before they added the homeless shelter ordinance, it was a completely ignored use. And so they did not have a provision in their code that prohibited non-identified uses, which meant that you would just kind of find the closest similar use and treat it that way, which is fine. I mean, that's much better than just a flat prohibition on all non-identified uses. But that's, I don't know if there's a national trend kind of one way or the other. I think there's, you know, homelessness is certainly an issue right now. And I think municipalities are struggling with how to handle it. Should I get the chat in the Zoom or no?
I have a copy.
Okay. Okay, great. Well then, why don't we scoot to the next section?
Okay. So some of the other zoning issues that we wanted to talk about, Diana talked specifically about some of the zoning provisions that directly impacted homeless shelters. We want to talk about a few other types of zoning categories that really have just the effect of taking certain housing options basically off the shelf or just making them a lot more difficult to come by. And so we'll go through a few of these. And the first one we'll talk about are how some zoning codes treat rentals. And in particular, what we're talking about here are long-term rentals. So we always see in the news Airbnb and VRBOs and the short-term rentals. And that's kind of like a different can of worms. But what we're really thinking about here are just traditional long-term rentals where somebody just lives in a home that as a tenant rather than as the homeowner. And if you look at media coverage of this issue or city council meeting minutes or comments that people give at these meetings, there's a perception that neighborhoods with a high level of rentals are viewed as less stable, that renters are not going to take great care of their homes, that just overall it will lead to a decline in the quality of the neighborhood. And so I think that's the perception that is driving a lot of these zoning changes. And then the other thing is there are, if you look at census data and other government surveys, there are systematic average demographic differences between renters and homeowners. Renters are on average younger. They on average have lower income. They on average are more likely to be minorities as compared to homeowners who live in their own home. And in terms of the impact that this has, obviously it's taking an option that a lot of people need for where to live, and it's just taking it off the table because it's basically saying that in some places or in some homes, you simply aren't allowed to rent. And then obviously that's also going to impact the cost of rentals because you're now artificially constraining the supply of available rentals because you're capping it. It's also just for the homeowner, it's denying their property right. It's denying them a source of income that they might want to rely on. They may, for example, retire and downsize, and they want to rely on rental income as a source of fixed income to help them to make ends meet. And people are being denied that right as well. And then I mentioned the predictable average differences between renters and homeowners. And so these rental bans obviously are going to have a disproportionate impact on marginalized populations as well. We'll switch to the next slide. And so we have up here, we have an example of one that from a case that we worked on many years ago that shows one example of how municipalities might limit rental housing. And this one in Winona, Minnesota, it actually did it in the form of a permit. So you have to get a permit to rent your home out, but then it caps how many homes on a given block are able to get these rental permits and then have permission to rent their homes out for a long-term habitation by someone. And you can go ahead and switch it. And that's, just as a quick sidebar, I mean, there's a lot of issues with zoning, but what I find really striking about the zoning restrictions is that the way zoning works is that it's trying to restrict uses. You can do one use here, you can do one use there. And what's remarkable about these is that you have the exact same use. Somebody who lives in a home that they own is using that home the exact same way that someone who rents that home is using it. And so it sort of contradicts the underpinnings of zoning to exclude these types of uses. But many zoning codes are doing that anyways. So we gave the example from Winona, Minnesota, but it's very common in Minnesota as we've seen, but we've also seen it spreading. And so we actually came across, for example, an example of where one of these restrictions was being considered in a county in Georgia, the Cherokee County Board of Commissioners. And they actually had a meeting, and they had a presentation, they had a slide deck. And they actually said, well, we need to do this because look at what all of our neighbors are doing in our surrounding communities. This community has this rental cap, and now this one has it, and now this one has it. And we don't want to be the ones who are left out. And now all the renters are going to come to our community, and all the rental housing is going to be in our community. So if they're doing it, we have to do it too. And then we also see it in a variety of forms. So the Winona, Minnesota one, they did it in the form of permits. You have to have a permit to rent your home. One that we saw in Clayton County, it focused kind of on the front end with developers and builders. And basically what it was trying to do was to keep developers and builders from building homes and then either directly renting those or selling them to somebody who would then rent them out basically as a business. And that can happen for a couple reasons. For example, there are some businesses now that are called build to rent. And so they will just build a neighborhood with the intention to rent those homes out right at the outset. And then sometimes plans change. Sometimes the market changes. Sometimes there's not as much demand to buy the homes outright as a builder expects. And so when they can't meet that demand, they'll turn to renting out the homes instead of selling them just to make the project feasible. And then another one that we've seen is it's a little bit more subtle. We came across this one in Cherokee County, Georgia. And what it did was it created these definitions of a for rent community and a for sale community, with basically the dividing line that a for sale community cannot have more than 10% of the homes rented out. And it basically attached this definition to almost all of the single family residential districts in that county. And then what it did was, so now most of the communities are for sale communities, but then you say, well, how do you enforce that? Because they don't have rental permitting. And so what they did then is when somebody wants to come in and build a new community, that community is zoned as a for sale community. And then to enforce the for sale community provision, they have to then enact covenants that run with the land that create a homeowners association that is then charged with enforcing that restriction that no more than 10% of the homes can be rented out. And that's really a subtle thing, because if you're an advocate, if you're a lawyer, you're thinking about challenging that. Someone comes to you and says, I want to rent out my home and I'm being told I'm not allowed to do it. Well, if you go and you look at it, it's going to look like it's just a private action. It's just a group of homeowners who exercise their right to enter into a contract about how their neighborhood is going to look. And you'd really have to dig down to figure out that actually this at the bottom, this really is a governmental decision that has said that we just don't want too many rentals in this neighborhood, and we're going to enforce that with the power of law. And it's also then becomes also difficult to change, because if you do make the persuasive argument that this is not a good thing for this community to do, you can't just lobby your city council member. You have to go and figure out how to remove all these covenants from this land. So it's that just makes it all the more difficult to actually try to bring change. It's hard to litigate. It's hard to change politically as well. So those are kind of some of the different types of ways that we've seen municipalities target renters and try to exclude them from the community.
We'll talk about accessory dwelling units for just a minute. So accessory dwelling units, ADUs, they're also called accessory apartments, second units, granny flats. They're additional living quarters that are on single family lots that are independent of the primary dwelling unit. So they can either be attached. So for example, a basement with a separate entrance, or an apartment above the garage, or they can be detached, a totally separate structure in the backyard, for example. The key is that it's an independent dwelling unit with a separate entrance, separate kitchen, temperature control, so on and so forth. ADUs were very common in early 20th century building in single family homes. These were a pretty traditional way of having different phases of family living together, or being able to rent out a piece of your property to draw a little bit more money, and to keep housing costs low. They were very helpful. The benefits, they produce the income for the owner. They increase the supply of affordable housing, which is particularly important in the midst of a housing crisis. And they don't require new infrastructure. They can connect to existing utilities. So it's not like putting in a whole new development out of town where you have to do a new road and sewer and water and everything. They just hook right up. And so zoning codes don't always treat them favorably. So many cities prohibit building an additional unit on single family housing zoned land, which is the majority of zoned land in a lot of these cities, which ends up making an ADU illegal. Many cities place lot setback requirements that make ADUs either impracticable or impossible to comply with. I mean, I should say for both of these things, I'm talking about the detached ADUs. It's, I suppose, a separate issue if you're talking about an above apartment or an above garage apartment, for example. And so many cities have ADUs with difficult permit review processes, discretionary requirements, which puts you at the mercy of a government official, lengthy proceedings, and then they involve unnecessary fees from owners, which again increase the cost of housing. And many zoning codes have a very narrow definition of family. And so this can limit occupants to kind of a traditional definition of family, however you want to define that, but spouses, blood relatives, nobody really beyond that. And so there's been some limitations in the courts on how they can define family, but not as much as perhaps there should be. And so to the extent that you have consenting adults agreeing to rent a piece of their home to somebody else, seems to me that should be the end of it. But that is not in many municipalities. So California did something really great in 2020. They passed this ordinance and a few others related to it that basically guarantees the right to build ADUs as long as they meet certain simple and pre-published criteria that are objective. This is a great step forward. It recognizes the utility of ADUs. Unfortunately, some local governments in California are resisting. They're either taking far too long to process these applications, or they're rejecting the applications for irrational reasons. But I don't want to go through the whole code here, but basically the state went through and made a series of legislative findings about the benefits of ADUs, and then said that any ADU ordinance adopted by municipality has to basically treat the ADUs appropriately, and that you can't just arbitrarily deny these applications and arbitrarily deny people the ability to use their land to have an ADU on them. So this is great. More states should do things like this. Reduces the cost of housing, again, lets people use their property in more ways. And then municipalities should comply with them once the state authorizes them.
So the next zoning category that we see refers to minimum size housing requirements. And these are sometimes called different things. You sometimes see it called minimum floor area, sometimes minimum habitable area, or minimum heated floor area. But the basic requirement is that the zoning code says that if you want to build a house in this zone, the house must have so many square feet of living area. And if it has less than that, you're simply not allowed to build it. And as you can see by the graph that we have here on the screen, houses now are a lot bigger than they have to be. They're a lot bigger than they need to be. There's nothing wrong with having a big house, but people have gotten by with smaller houses for a long time. We can go to the next slide. So in fact, if you look at this historically, if you look at this internationally, the US is often a bit of an outlier, and right now is a bit of an outlier. Homes didn't used to be as large as they are now, and homes around the world often are not as large as they are here in a few other countries, even when you're just looking at wealthier countries. And again, that's due to a lot of reasons. Where society is wealthier than it used to be, so people can afford larger homes. But what we're seeing is that a lot of jurisdictions, a lot of municipalities are actually mandating increasingly larger homes. And we have two examples here that really stick out. One small town in Alabama said all homes had to be 1,800 square feet. That was the smallest house you were allowed to build in that entire city. And they really, this small desert community that is practically uninhabited in Big Water, Utah. I mean, this is not, this is not like a suburb of Salt Lake City. I mean, this is like in a corner of the state, very sparsely populated. The smallest house you were allowed to build in most of the city was 2,000 square feet. Turn to the next one. Again, if we turn back then to the underpinnings of zoning that I mentioned before, zoning is supposed to be about separating incompatible uses, and there's a lot to complain about there, but it at least has a certain internal logic to it, that if you take it for what it says, it is trying to do something with an identifiable goal. But it's really hard to connect minimum housing side to what zoning is actually trying to accomplish. If you want to look at housing size requirements, you don't look to a zoning code, you actually look to a building code. And most jurisdictions in the United States actually adopt a variant of something called the International Residential Code, which is a bit of a misnomer. It's primarily a US-based code. But by its own terms, it is trying to set minimum requirements for a healthy interior living environment. And this code that is focusing specifically on safety, that's focusing specifically on a healthy living environment, doesn't set minimum home sizes. All it says is that rooms that you're living in, so a bedroom, a living room, has to have at least 70 square feet, and it has to be at least 7 feet wide. And I think you could probably even question the scientific basis for that. But I mean, that is at least an effort to say, this is what you need to be able to circulate within a room and to move around freely without being overcrowded. And the International Residential Code even specifically has provisions to deal with the unique circumstances of very small homes below 400 square feet. So by the terms of a building code, you can have a 200 square foot home that is perfectly healthy and safe to live in. But the zoning codes nevertheless are saying you're not allowed to build that home, you're not allowed to live in that home. We can go to the next one. And so why are people doing this? Why are cities doing this? You'll hear a lot of things if you watch the media coverage, if you go to the city council meetings. There's a lot of, Diana talked about harmony. There's a lot of vague talk about the characters of neighborhood, maintaining the character of neighborhoods, about not building small homes next to big homes. You hear a lot of talk about property values and tax base. And then you hear a little bit of talk about what is often, I think, driving a lot of this, which is that smaller homes are attractive to people with lower incomes. And so you hear talk about concerns with having problems with trash and litter. You'll hear people talk about potential crime problems if people are building smaller houses next to neighborhoods with larger homes. But as we've seen, and we interacted with people who want to build smaller homes, who live in smaller homes, there are a lot of reasons to do it. And part of it is just a lifestyle. People, they get older, they want to downsize, they want a simpler lifestyle, they want less clutter. The lower costs are an obvious benefit. You have a smaller home, it costs less to build because it has less materials, takes less labor to build it, takes less electricity to keep it heated and lit. People do it for environmental reasons. And then we have some cases that involve tiny homes on wheels. And so a lot of people like the idea that this home is my home, and if I want my home to be somewhere else, it can be somewhere else. And that's another great benefit of these homes. And so that's another policy that we are encountering, that are taking some affordable housing options and just taking them off the table.
So I'm gonna talk a little bit about feeding the hungry. And so little free pantries are kind of popping up around, and they are kind of like the little free libraries where you can come in and take something that you need and go home. You can leave something for someone else. And so I have a couple pictures up here from littlefreepantry.org. And the one on the left is really just like the little free libraries that, pop up all over my neighborhood, for example. Except instead of having books, they have canned food or whatever. But some of them are also really big. And so this one on the right is a lot more substantial. And the idea is just you come and take what you need. And you can feed yourself if you're really in a tough spot. But some municipalities prohibit them, of course. And so they prohibit them as an additional structure on property in a single family home zoned land. Some don't outright prohibit them, but instead they require that the people who host them follow regulations that are really designed for institutional food banks and soup kitchens. And so if you guys know anything about those requirements, they are incredibly onerous. They are difficult and expensive to obtain commercial kitchen, but either access to them or meeting the licensing requirements generally. And they are just very challenging. Some of these permit requirements, they're onerous to comply with. The permits are expensive to apply for. You have to provide insurance, which again is an added expense. You have to go through the process of applying for them. And so this is not just with food pantries, but this is sharing food on public property. And so again, you might have these commercial kitchen requirements, limitations on where the food can be prepared, not necessarily in your home kitchen, but at a commercial kitchen. The idea, I think, with a lot of these is to limit charitable feeding to private property in an effort to remove the homeless from public land. And the reason I think that is one of our cases that we just launched a month ago, where that is exactly what's going on. And we'll talk about that in a moment. Oh, we have another CLE credit, you guys. Code word shelter. That's an appropriate code word for this. Okay. So we're going to shift gears and talk a little bit about some of our specific cases that we have kind of alluded to and otherwise mentioned today. And so I'm going to start by talking about the Catherine Barber Memorial Shelter case that Lily talked about a little bit at the beginning. It's my pride and joy. It's my probably my biggest federal court win, even though it's just a trial court. A win is a win, and our clients are renovating this very building as we speak. So it's very exciting. But it was a long road to get there. So I want to back up just a little bit and talk about the Catherine H. Barber Memorial Shelter. It first opened in the 1980s, and it first operated out of a single family home in town. And North Wilkesboro is a tiny little town in northwestern North Carolina. It's in Wilkes County, and the Catherine Barber Memorial Shelter was the only homeless shelter in the county. They were the only ones serving this population. On a given night, they serve around 6 people. So it's not a particularly large shelter. They don't have a lot of capacity, but they were finding they wanted a little more space. And so this particular building was donated to them by a local dentist who he moved spaces. He realized he didn't need it anymore. And so he offered this to them. And they thought this was great. They decided to apply for a conditional use permit to obtain a permit for this building and then open up. And as you can see, it's right on a busy road. This particular town requires that they be in the highway business district. Well, this is the highway business district. This is what it looks like. It's on a highway. And there's a sidewalk in front of it. And it's far away from all the things it has to be. But they operated for about 30 years in town without a problem. This particular location satisfied all of the objective zoning criteria. And I know I keep harping on the objective zoning criteria. That's because it's an important part of all of this, is that if you're going to establish a set of standards that people can check off, great. They did that, but then they still were denied because people didn't want them in town. And so the town's Board of Adjustment denied them at a conditional use permit hearing. And so at the hearing, the board prohibited cross-examination of all of the people who got up to testify in opposition to the shelter. There was hostile testimony by about 4 would-be neighbors who portrayed the shelter's clients as criminal predators and addicts who litter the town with beer cans and drug paraphernalia, and shiftless beggars with no desire to improve themselves. They really just relied on stereotypes and tropes that aren't true. And so the shelter sought to cross-examine these people to show that this hadn't been their experience, that this wasn't based on facts, but the board prohibited them from cross-examining these witnesses. And as a matter of black letter law, you have to allow cross-examination. That just period, full stop. There was also no expert evidence presented. And that becomes important when we talk about property values in a moment. But so the hearing took about 2 hours, and that was based on the Barber shelter's testimony and presentation, the testimony by the would-be neighbors, and then the board's deliberation, which took all of 10 minutes. The board admitted on the record that the location met the letter of the law, but stated that that didn't necessarily mean it belongs there. Those are direct quotes from the board chair. They played a prominent role in our briefing. And so the board ended up denying the conditional use permit on 3 factors. The first was the impact on neighboring property values. They said that it would substantially injure the neighboring property values, and this was based on the neighbors' fears that their property values would decrease rather than any expert testimony or anything resembling it. There were no comps, there was no conversation at all about the property values other than it's going to decrease the cost of my business. The board also said that it was inharmonious with the nearby uses, which were a church, a gym, and other retail uses. And finally, they said that it would harm public health and safety because the distance between the door and the busy road, and then the proximity of the sidewalk, homeless people would walk all out into the street. That was the concern. Needless to say, disagree on a number of those things. And so we sued in federal court, raising 2 claims. And so we brought this pursuant to Section 1983 with the administrative appeal as a supplemental claim. And so this administrative appeal, the state law claim, we went through. And so I mentioned a bit ago, there was a 2020 case on behalf of a big hotel project that had applied for a conditional use permit and was denied for kind of irrational reasons. That really set us up to argue this claim. And so all of the non-cross testimony, again, that violates due process. All of that opposition testimony, the court struck immediately, saying that you just can't do that. You have to allow people to cross-examine. And so without all of that testimony, that left only the board's reasoning, which again, they had 10 minutes of reasoning. So there wasn't a whole lot there to go off of. And so the court then walked through each of the conditional use permits denials, or the reasons for denial. So on the first, property values. North Carolina law requires expert testimony on property values. And so again, earlier we talked about ensuring that it's either not going to substantially impact property values or that it be a public necessity. The board didn't consider that at all. They just said, well, it's going to affect property values, so therefore we're going to strike it. Well, can't do that. You don't have expert testimony to be able to do that. And then for harmony, the interesting thing about harmony is that if the zoning code has approved a particular use in a particular location, that creates a presumption of harmony. You can't then say, well, it's inharmonious if you don't have a specific reason for it to be inharmonious. And here there was nothing there. Whether it's next to a church or a gym or another retail use, there's nothing specific about any of those uses that clash with the ability of a homeless shelter to exist. And then finally, with public health and safety, the sidewalks and the proximity to the road are required by the zoning code. You can't in one breath say it has to be in this district, it has to have a sidewalk, it has to be this close to the road. And then in another say, well, those reasons make it dangerous. You just can't do that. So court went through all of these, concluded that the board had failed to rebut the Barber shelter's presumption that they were entitled to the conditional use permit, which is great. Hallelujah. But that's not it. That didn't resolve the full claim. That didn't provide us with full relief. And so we were able to move to the equal protection claim. And this was a strategic move that we made because we wanted to provide the most relief to as many people as possible. For us, this isn't just about this particular homeless shelter. This is about anyone facing a conditional use permit denial. And, within the Fourth Circuit, we weren't sure if they were going to appeal or not, but we wanted to make as broad of precedent as possible. And so even with the state law win, all that said was that the conditional use permit had been inappropriately denied. And so they would, if they ever moved, they would have to go through the same application process again. They would have to face the same people again. And that wasn't sufficient under our claim. So we were able to argue a constitutional claim. And this was the really fun one. So I mentioned earlier the city of Cleburne case. Are you guys, will you raise your hand if you're familiar with Cleburne? Okay. That's totally normal. Cleburne is a watershed decision that has been totally ignored since it was issued in 1985. I had a clerk this past summer go through and look at every case in which it's been seriously discussed. And there's fewer than a dozen federal cases talking about it in more than just a passing, this is the standard for equal protection claims. So I'll talk about Cleburne for a little bit. So this is out of Texas. There was a group home for the intellectually disabled and they had to apply for a special use permit. And so they went through and applied for it and they were denied based on a series of bogus reasons. And so the Supreme Court first started by applying the rational basis test instead of a heightened level of review. So I bring that up because the Fifth Circuit had applied intermediate scrutiny because these are folks who are intellectually disabled. On the tiers of scrutiny, to the extent that there are immutable characteristics, those usually get higher scrutiny. And so the Fifth Circuit said, okay, well, under intermediate scrutiny, government loses. The US Supreme Court said, nope, this is rational basis land. But the government can still lose under rational basis, which is something that at the Institute for Justice we're very passionate about, fighting the rational basis test and expanding it. And that's what the Supreme Court did, and that's why we like Cleburne so much. And so the city of Cleburne also didn't require special use permits for many comparable uses, despite using the land in the same way. And so the government there basically denied the permit on a series of kind of bogus reasons, like I said. Public opinion was poor. There was a neighboring junior high school, and perhaps that would be dangerous to have the intellectually disabled nearby. The home was located on a 500-year floodplain. There was concern over the legal responsibility of the actions of the residents, like who would take responsibility for them. Let's see. Oh, the size of the home and the number of people to be housed, despite the fact that the living center complied with all of the other requirements for maximum number of people in a space. They were concerned about lessening street congestion. And that was about it, those 5 kind of reasons. I guess those are 6. So the Supreme Court went through each of them, applying rational basis, and said, look, none of these actually survive scrutiny. To the extent that you have a concern about the neighboring junior high school, well, there's no reason to justify that. There's nothing kind of going on here that would provide evidence that exists. And so the court went through each reason and knocked all of them down and said, okay, well, then all that's left is animus. And animus is not a rational basis. And so Cleburne is delightful. I would commend it to everyone's attention. It's a really good case. I will say that it uses 1985 language. So I just flag that. It doesn't use the phrase intellectually disabled. But it is in substance a really excellent case. It does a lot of work. And and it's ignored a lot. The 11th Circuit a few years ago said that it was all but overruled. No, it's never been overruled. Like that's not how the 11th Circuit can't overrule the Supreme Court. The Supreme Court relied on it in as recently as 2018 in a majority decision. And that was just for the standard of what equal protection means, but that means it's not overruled. Like they're still relying on it. So in any event, Cleburne is a delight. So I'll go back to our case at hand here. The court then went through and applied Cleburne to the facts at issue here. So there was no conditional use permit required in North Wilkesboro for 128 uses. This included group care facilities, nursing homes, emergency shelters. I should say in the highway business district, which is the only district we're talking about here. So all kinds of uses could go in this exact location without having to meet this conditional use permit requirement. The only uses that had to get a conditional use permit were used car lots, cell phone towers, nightclubs, bed and breakfasts, and homeless shelters. And so the question then that Cleburne demands is the Barber shelter treated differently than these similarly situated uses? And so the key question is, like under similarly situated, is are the uses comparable with respect to the legislative aim? So it's not just, does a person sleep there, but it's how is this land used? Why do you want to regulate it in that particular way? And so the court, went through and applied Cleburne to the facts that we had here. And they said, all of these justifications are bogus. You could have a pizza parlor on that exact same road that's still next to the busy road, that's still the sidewalk where people could presumably be drinking. And that's allowed, and they don't have to prove that it's safe or whatever to use it. They just automatically get a permit. And so once the court went through all of the different justifications, all they're left with is animus for the residents. And as we know, animus is not rational. So this is an equal protection violation. So I know that Lily included some of this language before. This is just music to my ears every day. So I read it before I go to bed mostly. But it was, because we didn't know kind of what was going to happen. When you litigate a rational basis case in federal court, you have quite the Sisyphean task. But you just go through every justification, you rebut all of them, you show that everything left is irrational. And we got a judge that was willing to engage with the facts at issue. And this particular judge was a Trump appointee. And when he walked into the hearing, the motion for summary judgment hearing, I was not sure what to expect. And I stood up and gave my presentation. He asked questions and gave me a hard time about the bed and breakfast example. He was like, well, aren't these pretty similar? So we went back and forth on that a little bit. And then I sat down and my opposing counsel stood up and I was like, oh, well, this is, he got a harder time. And they just didn't have an answer for many of the things that they had done. And so anyway, we won. We got this beautiful decision and the other side did not appeal. So now our client is renovating that building that I showed you at the beginning, and they hope to be able to open shortly. Renovations take a long time, but in the meantime, they've been operating out of a church that's just outside of town. And so they should be able to open soon and get right back down to what they've been wanting to do since they applied for this several years ago. So that's the Barber shelter. We'll shift gears.
So I'll talk briefly about another case we have on behalf of our client, Tiny House Hand Up Inc. And so this case involves a challenge to the city of Calhoun, Georgia's regulations of minimum home sizes in residential districts. And so the zoning code has a Balkan area regulation for all of its residential zones, but including our client's zone, which is R-1B. And so it has lots of things like minimum lot sizes, setback requirements, but relevant here, it says minimum floor area, all homes in this district must be at least 1,150 square feet. And that is like the smallest that's like the densest residential district that they have in their zoning codes. They actually have, a lot of the cities actually zoned to require even larger homes than that. And so our client, Tiny House Hand Up, is a nonprofit organization that is about as grassroots as you can get. It was literally just a few people in the community started interacting with people who were struggling with housing in the area, and decided they wanted to do something about it. They wanted to make a difference. So they formed this nonprofit to do what the name says. They thought that if they could build tiny homes, that would give people a hand up to a better life, to a better situation. And they've had a lot of different things that they wanted to try, but one specific thing they wanted to do was to build small homes on land that was donated to them for the purpose of building smaller homes. And then their idea was they would it wouldn't be a condo, it wouldn't be subsidized housing. They would just sell the homes outright to people who are priced out of the current market, but who could afford a smaller home that costs substantially less than most of the other options in the area. You can do the next slide. And what's amazing about what happened here was the land that was donated to them, it was, when they received it, it was actually zoned for industrial uses. So they could have, when they received the land, they could have built a light manufacturing facility, a truck terminal, a scrap metal processor, a lot of things that traditionally, when you look at zoning hearings, things traditionally people don't want to live next to those things. They don't want to live next to an auto service station if they have a choice. And Tiny House Hand Up could have built that by right if they wanted to, but that's not their mission. So they said, we want to rezone this residential, and then we want to build smaller homes. And the city said, residential, yes, you can build homes here, but it said smaller homes, no. And then they applied for a variance, basically zoning variance, where you apply for a specific exception to the normal zoning rules. And the city held hearings, and much like what Diana described with some of the hearings for the Barber Memorial Shelter, people complained. Neighbors came in and complained and said, these are not the type of people that we want to have as our neighbors. One woman even stood up and said, building these homes is going to attract quote unquote riffraff. And so the city then went and denied the variance and said, sorry, you cannot build your community of small homes. So we're challenging that right now. We are really in the thick of it. So the case is still at the beginning stages. We're on appeal on some early kind of procedural disputes. But the case itself involves two claims. One, we're bringing a claim under the Georgia Constitution Due Process Clause, basically saying there's a substantive due process under which zoning restrictions must bear a substantial relationship to public health, safety, or general welfare, and telling people that they cannot live in a small home just has no connection whatsoever to any of those interests. And then because you have to exhaust administrative remedies under zoning codes, there are various procedural rules in place. We also have to bring a statutory claim, basically seeking a writ of certiorari, basically saying that when we applied for this variance, as a matter of the city's ordinances, it basically misapplied the law when it, without evidence, denied our variance. And so that basically treats the city council that denied the variance as a quasi court. It was hearing evidence and making a decision, and then we're appealing that decision to the Superior Court. And just to give you an idea of what we're dealing with, one court of appeals described that process, that writ of certiorari process, as it said that whole statutory scheme seems to refer to some archaic proceeding, which is a mystery today. And these are the courts that are interpreting that, are basically throwing up their hand and saying, we don't really know how this works, but you litigant, try to figure it out, because otherwise we'll dismiss your case. So that's that case.
So I want to talk about one more case. I realize we're running a little bit low on time. I could talk about this stuff forever. But another pending case that we currently have is on behalf of Norma Thornton. And so this is a 78-year-old grandmother who had been feeding those in need at a public park in Bullhead City, Arizona for about 4 years without incident. The picture you see on screen is from a body cam of a police officer who was arresting her in March of this year for feeding the hungry in a public park. And so we launched this case at the end of October. The video that we have, it's on YouTube, it's on our website, went fairly viral because it's the police arresting a grandmother for feeding the homeless. But I want to talk about it a little bit more. So the city had passed an ordinance that requires a permit to share food for charitable purposes on public land generally. So there are exemptions that cut a substantial series of holes in this ordinance. So it does not apply to sealed prepackaged food available from retail stores. It doesn't apply to social gatherings. It doesn't apply to food distributed for non-charitable purposes. And it doesn't apply for food for sale. So that means that Norma could host a pizza party for 50 of her friends without a permit, but she cannot serve the exact same food in the exact same location to those in need unless she gets a permit. Well, why doesn't she get a permit? Because getting a permit is extremely restrictive. She has to request it between 5 and 60 days before the event. She has to pay a $30 permit fee and then a $250 deposit. She has to obtain $1 million of insurance, naming the city as the indemnified. And then she has to get a county health permit, which essentially requires that she meet industrial food kitchen requirements. She does not do that. She cooks food from home, from scratch at her house. And not having a permit is a criminal offense. Each location is limited to 1 event per month, and each person is limited to 1 event per month. Norma feeds about 4 days a week, and so she just couldn't do this. So the city ended up dropping the charges against Norma, dropping the criminal charges, but they told her they would do it again and she would spend the night in jail if she ever fed the homeless on public land again. So we're suing them because this violates the 14th Amendment. So we have a case pending in federal court. We've raised claims under the due process clause, substantive component of that. We have an equal protection claim under Cleburne again, and then we have our privileges or immunities clause, which is something that we're very interested in, but it's just preservation for the Supreme Court because that's been impossible since the slaughterhouse cases in the 19th century. So anyway, so that case is currently pending. I realize that we have gone almost to time, but if you guys have any questions, I'm happy to take them. Thank you. Yes, ma'am. Thank you.
Why couldn't she just play these with her friends and let it be that? Why are they throwing such a fit that these are needy people instead of just people? And she's sharing because they have to be knowledgeable of each other.
Right.
So wouldn't that associate a relationship?
So you might think so, but the city's goal in passing this ordinance was to eliminate homeless people from the parks. They said this over and over and over again in their city council meetings, which I will be sure to include in all of our briefing. But their goal is to eliminate those people. It would be fine if she had her real life friends, but it's not fine to have transient friends. That's another word that they keep using. And so it doesn't matter that she knows them. It's a charitable, her goal is charitable. So now she's feeding in a private alley right now. And she can't feed as many people as she would like, but it's better than nothing. Yes.
Thank you for this wonderful presentation.
Thank you.
It's great. I have a question about sort of the ADU zoning you were talking about, and specifically around vehicles, because there's a lot of people living in RVs, and a lot of, particularly in the western states, about half of people living in some cities on the streets are living in RVs and vehicles. Have you seen much around ADU stuff for providing space for vehicles? For example, in Oakland, they've recently started a program called the residential vehicular program, where they actually use special occupancy, special mobile home park permits to allow people to park and rent a space for a vehicle, as long as it maintains under the rights to water, electricity, all that kind of stuff. Have you seen any other things around that, around providing space for vehicles under EDU?
So I don't know that we've seen them connected with ADUs as much. We do have a case pending in Sierra Vista, Arizona right now on behalf of a woman who lives in a mobile home and has been told she has to leave despite mobile homes being allowed next door. And so, you know, we found a lot of municipalities do want to eliminate these kind of lower income uses. And so they go about it in all kinds of creative ways. You know, we can't fight over all of them, but that is one that we're currently challenging. So it's separate, I guess, from the ADU issue, but still about kind of the vehicles generally. Yes, ma'am.
Where could we follow the progress in the process on the two pending cases?
So ij.org is our website. These are our emails. We put everything online. The way that we exist as a nonprofit, we litigate in the court of law and the court of public opinion. And so it helps to have a grandmother to represent in these cases because she's very sympathetic and garners a lot of attention. So we put everything online. You can follow it there. We have our Twitter account, our like all of our social media accounts kind of update as things go. But we're also, I think, happy to talk with anyone who emails us with questions.
We're facing similar circumstances. I understand.
Be happy to chat with you about that in particular. So, Lily, did you have your hands?
Yeah, so right now in another breakout session, they're talking about panhandling and First Amendment cases, and often like food sharing cases they bring First Amendment claims because food sharing can be protected speech activity. So I'm wondering, like, what is the reasoning to bring 14th Amendment versus First Amendment claims, or like reason to not do both, or
So there are a variety of different kinds of claims that can be made. And so when we launched the case on behalf of Norma, we thought long and hard about what we wanted to bring. We ended up not bringing a First Amendment claim for a variety of reasons. One of them is so there's the religious aspect of the claim and then the free expression aspect. So after this last Supreme Court term, both Dobbs and Bruin were issued, and they talked a lot about historical trends and how you can have an unenumerated right as long as it's based in history. And so this is something that the court has long said, but I think this last term really emphasized how important this deeply rooted in tradition. Well, there's nothing more deeply rooted than caring for those around you when you can do that. And so that's something that we want to advance. And that's something that we really want to kind of go and see how far we can go. And so the town that Norma lives in, when they were considering this ordinance, they were only concerned about Martin, which I know there's a lot of talk at this conference about Martin. That was the only thing that the city was concerned about. And they have some of a Martin problem. We're not litigating an 8th Amendment claim. We're only focused on this 14th Amendment claim because we think that there's an opportunity there to expand into this unenumerated rights as a fundamental right, really. So litigation decision, I guess, is the best way to describe it.
I have a follow-up.
Yes, please.
So I'm like, I also love the Barber decision. I was like so surprised that particularly that federal court like gave you an equal protection win under rational basis. And like, for those who aren't like litigating in the room, poverty/wealth status and housing status, neither of those are protected classes. So you only get rational basis review, which is the lowest form of scrutiny. Basically just means that the government only has to prove that there is some rational basis for what they're doing. So I'm curious, like, do you think there's room in like our broader movement to try and get those rational basis decisions on equal protection grounds, like pushing for equal protection claims based on discrimination against poor people, discrimination against unhoused people, or do you think that it's really because the zoning situation is sort of so unique?
So I think there's certainly room for it. I mean, it's not like this was a once in a lifetime case. There is room for it. These cases are very difficult to win. We had a perfect storm of events where like everything that they did at the hearing was ill-advised, and we were able to use all of that to our advantage. We've been litigating rational basis cases since we opened our doors. And when we first opened our doors in 1991, people said that we were absolutely insane for litigating rational basis because there's just so much bad case law. Well, that's true, but there are things that the government does that's irrational, and this is an example of it. And so there's so much bad case law under the rational basis test that in some ways you can't make it much worse. But when you have this like kind of perfect storm of events. And so I think we have a similar situation with Norma's case, where we have them saying everything that they shouldn't say out loud at city council meetings. And so, we'll go through discovery, we'll go through the same kind of litigation process we always do, and really use all the discovery tools that we have at our hands and drill down. But you can't get away from the fact that they're saying they're trying to exclude homeless people. And that's just not an appropriate government use. Homeless people are part of the public. People in the public use public parks. That's just what they do. And so I think there's a lot of opportunities here. This is certainly an area that we're interested in continuing to litigate in, and that we're always looking for more cases. And so if you guys have any, let me know. But I think there is a lot of opportunity here, not just for us, but for a lot of folks who, just because the rational basis test is what applies doesn't mean the government has to win. Government usually wins, but they don't have to. So. Well, thank you guys. I'm sorry we went over, but like I said, let us know if you have any questions. Thank you.
Just a quick last plug, if you haven't signed in and you need CLE credit, make sure you sign in. And for those who need to know where they're going next, then this room is going to be vehicle residency and sexual violence with Graham. And Strowski is helping the helpers, hot topics, and representing community organizations working to end homelessness. In Strauss-B, we have Stopping Cicero, and in Strauss-C, we have Decriminalization Advocacy Post-Mortem. Thanks, everyone.
It's a great presentation.
Thank you. Appreciate your coming and appreciate your question.
Absolutely. To present on vehicle residency.